Hello, everyone. Yes, may it please the court is a comfortable way for me to start. I'm Jonathan Eisenman. I'm a lawyer representative and soon departing member of the conference executive committee. Over the years, this conference has privileged me to meet preeminent scholars and practitioners in their fields and to introduce them to you. Today, I have the honor of introducing three people with serious expertise in administrative law. They're here to speak about the demise of the Chevron doctrine after last year's Loper Bright decision, and more importantly, how courts and lawyers move forward from there. To my far left, Eugene Scalia co-chairs Gibson Dunn's administrative law practice. He served previously as the Secretary of the United States Department of Labor and the Labor Solicitor, which is the department's general counsel. To his right, Abbe Gluck is the Alfred M. Rankin Professor of Law at Yale Law School. She's one of the nation's leading scholars in the field of statutory interpretation and regulation and co-author of the leading textbook on the subject. She, too, served previously in senior government positions, including as the lead counsel on the White House COVID response under President Biden. To the far right, closest to me, and moderating the conversation between Secretary Scalia and Professor Gluck, is Revesz, the AnBryce Professor of Law and Dean Emeritus at NYU School of Law. From January 2023 to January 2025, he was the administrator of the White House Office of Information and Regulatory Affairs, which, for anyone who doesn't know, oversees the promulgation of all significant executive branch regulations. I've hit only a few highlights of the speakers' impressive careers. You'll find more of their biographies in the conference app, and you'll find question cards on the tables. We're on a compressed schedule this morning, but conference staff will collect question cards if you hold them up, and the panel will answer if they have time. And now I'll stop using that time and yield the floor to Professor Revesz. Thank you very much.
Thank you so much, Jonathan. I'm really honored to moderate this panel, particularly because Abbe and Gene are such extraordinary panelists. So to get us started, they'll each focus on some highlights of the case, and then I'll ask several follow-up questions to help us better understand the significance and also the relationship of the case to related doctrines. So Abbe will go first to tell us about some highlights that we should know about.
Thanks, Ricky. Thank you, everybody. It's really such a pleasure to be here this morning with you. So, as many of you know, almost exactly a year ago, the Supreme Court overruled what had been, until then, the most cited case in the US reports, Chevron versus Natural Resources Defense Council, a 1984 case that installed a regime of deference to agency statutory interpretations. As you probably remember, under Chevron, if a statute had room for interpretation or an ambiguous term, courts would generally defer to the agency's interpretation as long as it was reasonable. So the case ushered in 4 decades of judicial reliance on agency expertise, and it also created a situation in which a capacious term, the meaning of which could switch depending on the administration. So for example, the word sex in the Affordable Care Act's non-discrimination provisions has swung back and forth depending on who's in the seat as to whether or not it includes gender-affirming care. That's because of Chevron. Loper Bright, the case we're talking about today, overruled that regime. And it required courts to use their own independent judgment to decide even very technical questions. And it put an end to this idea that statutory meaning can change over time. So I'm very interested in talking with you about specific applications of various doctrines to Loper Bright, like Skidmore deference. But I'm going to save that to a later question and just use my brief opening to sort of provide a landscape of what Loper Bright means for judges and lawyers at a very basic level. So at a very basic level, what Loper Bright does is this. It tells judges and lawyers that we have to shift the inquiry from a question of ambiguity when we're talking about agencies to the question of what is the single best interpretation of the statute, just like you would have for any other non-agency question. So, for example, let's say a statute gives the agency the ability to regulate the interstate sale of pets, and the question is whether a domesticated ferret is included. In the olden days, under Chevron, lawyers, judges, the agency might say there's room here, and we would defer to the agency's reasonable view. But the ballgame has changed now. Ambiguity is not your friend, and that meaning of pets is going to be fixed forever once the court decides what it means. So everybody, whether you're a judge, whether you're an agency, or whether you're a lawyer, has to do the same thing and argue that there's one single best interpretation of the statute and that supports your view. Now, a lot of judges are going to say, well, that's ridiculous. That's a fiction. There's not a single best interpretation of a statute, especially when it's something very technical. And others might say, well, that's what we judges and lawyers do all the time when agencies aren't in the picture. And it's true that some of the Chevron cases did not involve expertise, did not require particular technical expertise. But it's also true that a lot of them did. So judges are going to have to figure out now how they're going to get to that answer. And for some judges, it might be that your process and your opinion look kind of different. And what do I mean by that? What I mean by that is that our Supreme Court is a very textualist court, as most of you know. And our Supreme Court likes opinions that are based on dictionaries, ordinary meaning, quote unquote, whatever that is, and the words of the statute and how they compare to similar words or different words in the US Code. And for a judge trying to decide a technical question, that just might not be enough. And the judge might want to look to other things. Right? The judge might want to still consider the agency's view. And we're going to talk about that. The judge might want to consider the goals of the statute or the purposes of the statute, as many agencies actually traditionally have always done when they're regulating. But whatever that process is, the opinion, if you don't want to be reversed, right, is going to have to at least be grounded in the idea that the judge is exercising their own independent judgment and ideally using these textualist tools that our Supreme Court appreciates and wants to see. I'm going to quickly note one more thing, and then I'm going to stop. I want to note that Loper Bright does not mean that there are no more delegations. In the opinion, the court expressly said, well, Congress can still tell an agency to fill in the details, or Congress can signal with words like reasonable and appropriate when it tells agency to set standards. And so, hey, there's a lot of delegation left. But I also want to make the point that the court didn't give us the full story when they said that. And the reason is that baked into the court's favorite assumption about ordinary meaning is this idea that Congress doesn't delegate big questions to agencies without being crystal clear. So that's the major questions doctrine. We're going to talk about it later. But on this point, when it comes to ordinary meaning interpretation, which is what Loper Bright is telling judges they need to do, part of what our current Supreme Court is insisting on is baked into that. There's this inherent presumption that whatever delegations you may see, they have to be presumed to be restrained and narrow. I'll stop there and reserve my time for other things.
Okay, highlights from Gene now.
Ricky, thank you, and thanks to all of you for having me here. I think that was a great summary of what Loper Bright is about. I think of Loper Bright as setting forth one very strong rule and providing 3 assurances to accompany it, one of which is subject to a potentially really important limitation. So the rule you heard, and that is, we're judges, we interpret the law, that's our job, get to it. We can talk about that later. So the assurances. The first, Abbe just touched on, which, of course, there is a place in our system of government for delegation to agencies. It happens in a number of different ways. Abbe touched on a couple of them. Our job as judges is to identify when such delegations have occurred and to police the boundaries, to make sure that when there has been some form of delegation, the agency stays within the authority conferred. That's the first assurance. The second assurance is, hey, overruling Chevron doesn't mean that there won't be agency expertise out there that you could rely upon. We have the Skidmore doctrine, so-called Skidmore respect. And so getting away with Chevron does not mean that we care not at all what the executive branch has to say. We'll talk about that in a moment. The third assurance is that Chevron precedents are not necessarily overruled. So, the message is, hey, look, we're overruling Chevron. We're not telling you that every single case we've ever decided that relied on Chevron is now no longer good. I said 3 assurances, 1 limitation. Let me just mention the limitation. It's on the first assurance, the assurance that, hey, fear not, the regulatory state is still here in all its glory, or at least a lot of it. The non-delegation doctrine is the limitation on that. And the Supreme Court, at a couple points in its decision, says, in policing the boundaries that have been set down by Congress, of course, it's our job, too, to make sure that that delegation has been within, quote, constitutional limits. That's in the background. We can talk about it more. I thought I would talk just a little bit more about the third assurance. Hey, just because we're overruling Chevron doesn't mean that every Chevron-based decision has been thrown out the door. I want to focus on the specific language the court used at one point in this relatively short paragraph. It said that overruling Chevron does not mean that, quote, the holdings in those cases that specific agency actions are lawful are hereby overruled. So the court is saying the holdings in those cases that specific agency actions are lawful, those are still good. So give you a case, give you an example. Sixth Circuit, the net neutrality decision. This is an issue that's been litigated time and again. It's a rule that keeps getting done by different administrations. And at the outset of addressing the legal question in that case, the Sixth Circuit said, well, actually, the Supreme Court has already addressed the question of whether the service at issue here, internet services, are telecommunication services or information services. And so, arguably, we're bound by that Chevron-based precedent. In fact, that Chevron-based precedent was a really big one, right? It was Brand X, which is a major Chevron precedent. But the Sixth Circuit said, no, Brand X, really, we can move on pretty quickly, even though it's a major Chevron precedent, because the, quote, specific agency action there was a rule 22 years ago, interpreting what's an information service. But we've got a different regulatory action. This is a new rule. And so, we're not going to worry ourselves about what the Supreme Court had to say in Brand X. That's a narrower reading of what I'm calling the Chevron assurance than some of you might have thought was appropriate. Certainly there are other cases where courts' view is here is a particular statutory interpretation. It was articulated in a Chevron context, but that interpretation is still good. The Sixth Circuit treated it differently. I don't think the Supreme Court's language, talking about a specific agency action, I don't think that was accidental. Why? Well, because what is a Chevron-based precedent? It's not actually a decision that the agency reached the single best meeting. That's now the court's job, as Abbe said. So that holding didn't even reach the single best meeting. I think the court was a little reluctant to go so far as to say, hey, anything approved under Chevron is unassailable. Where that gets potentially really interesting for me, challenging for you, judges, is adjudications are also specific agency actions. And the interpretation and application of a legal term in an adjudication context, arguably under this language, is limited to that case and is not necessarily a sort of Loper Bright protected Chevron precedent. So that's an issue that's out there. I think courts, you see, are already starting to wrestle with it. I've seen it a bit in this circuit. I want to wrap up with two kind of predictions. One, Loper Bright will make a difference. People often ask this. Does it really matter? From the perspective of having been in an agency, and Abbe, you touched on this flip-flop back and forth, every administration. The court watched that for 40 years. Agencies got more and more adept at overruling their predecessors. I did it. Then it was done to me, at the Labor Department. And I think it's one of the reasons that Chevron was overruled. And we will see less of that. The second prediction that I'll make is that there will be special pleading. There will be agencies that administer statutes or people who litigate under them that say, oh, my statute's special, Your Honor. Loper Bright, Chevron, we predate that. Or my statute's just really complicated. We've already seen this with the National Labor Relations Act. There's a Third Circuit decision which says, hey, deference to the National Labor Relations Board predated Chevron. And the Chief Justice in Loper Bright distinguished some earlier NLRA precedent. Well, let me tell you, my view is that does not mean the NLRA is immune from Loper Bright. But it'll be an interesting question. Those of you who deal with that statute a lot know that there are a lot of broad terms for judges to interpret. Last prediction, or rather, the other area where I think we will see some special pleading, and we can talk about briefly, is immigration.
Great. Terrific. So let's start out by talking about the significance of two issues that were explicitly raised in the Loper Bright opinion. And I want to probe a little bit of how big a deal these are. So the first is Skidmore. Abbe mentioned it. As you know, under Skidmore deference, interpretations and opinions of the relevant agency made in pursuance of official duty and based upon specialized experience constitute a body of experience and informed judgment to which courts and litigants could probably resort for guidance, even on legal questions. So this is a quote from the Loper Bright opinion. So will Skidmore deference play a greater role after the overruling of Chevron than it has before? And if so, how much difference will the overruling of Chevron make? And Abbe will address this question first.
Yeah, I'm super interested in this question. So the Supreme Court cited Skidmore 8 times in the Loper Bright opinion. So led people to think, well, Chevron has taken away what was there before, this sort of optional deference to the agency to the extent their opinions were persuasive, would remain, and sort of what would it look like, right? So Justice Kagan, I'm told, at this conference last year, actually predicted that this Skidmore question would be very confusing in the lower courts and would sort of lead to chaos. And she was, I think partially right. So let me just talk a little bit about what's been going on. So even though the Supreme Court cited Skidmore 8 times in Loper Bright, the court did not mention Skidmore once this term. However, in case after case, you still get deference, lip service to deference to the agency. And let me just give you a couple of examples. Justice Kavanaugh in the vaccination case, Justice Gorsuch in the weapons kit case, Justice Kagan in the FCC case. In each instance, they interpreted the term using their own independent judgment, and then they said, by the way, the agency has interpreted this term in the exact same way for a really long time, as if to sort of wink and say, see, we got it right. It's also pretty interesting that several times when some of the justices made this kind of shadow Skidmore reference, they didn't say Skidmore, but it was a sort of a shadow Skidmore, the court used this idea of history and tradition. They said, we respect history and tradition, and therefore we care that the agency has been taking the same decision, same interpretation year after year. Now, I, for one, found it a little bit interesting and a little bit jarring to see this language about history and tradition, which we know this court really likes, sort of redeployed as a way to justify some kind of continued link to agency expertise. And so the question is, what does that look like in the lower courts? So with respect to the lower courts, Justice Kagan's prediction is largely accurate. 3 circuits haven't referenced Skidmore or done any kind of shadow secret Skidmore the way that I just mentioned the Supreme Court seems to be doing it. The 9th Circuit is a leading user, a leading citer of Skidmore, but recognizing in each case that Loper Bright says you must exercise your own independent judgment, but that agency opinions still deserve respect, if not deference. In the 6th and the 11th circuits, there have been very divisive debates with emotional dissents between the judges on those courts, debating whether this idea of Skidmore, respect for the agency's view, you should even survive Chevron at all. So one question here is, also one more thing before I say the one question. One thing I want to mention is, in some cases here in the 9th Circuit also, when the court references Skidmore, sometimes it sort of wraps it up in this idea of precedent, right? Because we looked to this agency's view in a previous case and respected it, we're going to do it again now, right? So it's sort of a way to continue that reliance based on age-old precedents. What's been pretty interesting to see, and Eugene just alluded to it, which is new, is that these Skidmore citations seem to be bubbling up with respect to certain areas more than others. So if you look across the circuits, we're in the context of the BIA and the context of the NLRB, you've got a lot of these Skidmore references from the circuit courts saying, we're still going to look to these interpretations by these expert agencies. You're seeing a lot less of that in the healthcare context. And I'm going to guess we're seeing a lot less of that in the environmental context, but I need to look to Ricky for that later because that's not my area. But one question is, why is the subject matter divergence emerging among certain agencies that might continue to get this Skidmore respect and other agencies that might not? The last thing I want to say about Skidmore is one question everybody asks, including in the dissents, is what are we doing? Like, what is it? Why are we citing it at all? Right? Is it window dressing? Right? If courts are supposed to exercise their own independent judgment? Or is it that some courts really want to be able to say that they have, in fact, looked to this expert agency view and want to find a way to cling to some guidance for technical expertise when they don't know what when the question is difficult or technically complex? And the prediction that I'll make, since Gene has opened up the door to making predictions, is I think that it's very possible and quite likely that Skidmore deference is just going to become one more tool in like the bucket of interpretive tools that lawyers and agencies use every day, like legislative history, like textual canons, like dictionaries. It's going to be one of the things that judges and lawyers reference. For the Supreme Court, that's a challenge that I would put to it, because our Supreme Court is avowedly textualist and says it doesn't look to this external data points, external context. So they're going to have to find a way to square the circle some way to continue looking to agency expertise, even within their sort of textualist landscape. I think for the lower courts and for lawyers that are litigating in the lower courts, it's always been the case that the lower federal courts are much more eclectic when it comes to the interpretive methodology that they accept. Lower federal courts look at goals and purposes and even legislative history. So it's much more natural to think that at least the briefing that comes up is going to benefit from that Skidmore expertise, even if the opinions maybe push it to the side or minimize it, and even if by the time it gets to the Supreme Court, it'll be baked into the opinion, and the Supreme Court is going to have to grapple with how it's going to argue that continuing to look to the agency's expertise as it did last term is still consistent with an ordinary meaning approach. I think, like in the major questions case, you're going to see opinions that say something like, a longstanding and consistent agency interpretation is evidence of ordinary meaning. I think they're going to bake it into ordinary meaning, just like they've baked in major questions, because that's sort of the language that they're comfortable with.
Yeah, I'll just make a couple additional comments about Skidmore respect, which is what the term the Supreme Court began using in Loper. The first is, as most of you know, historically, Skidmore respect or difference, as it once was really worth very, very little. It was interpreted to mean, hey, if you're right, you're right. If I'm in an agency and I ask my lawyers, what kind of deference are we going to get on this issue from the courts? And this is hypothetically speaking. This isn't me. This is like hypothetical agency head. And the answer back is Skidmore deference. I'm like, oh man. Wow, I guess we got to get it right. And so Skidmore, not worth a lot. That kind of leads to my second point, which is the court that wrote Loper Bright will not accept Skidmore becoming Chevron light, Chevron in disguise. It's just not going to happen. They were very strong in saying that it's our job to interpret statutes, and they're leery of deference. Third point, I'm a judge. There's an agency interpretation. It gets Skidmore respect at best. I'm going to read what they had to say. I'm going to think about it. I may decide to put that up front when I reach the very same interpretation, or I may interpret the statute for myself, and then at the end, look what the agency has said, and lo and behold, it's just what they said. I guess that's more evidence I'm right. And I've seen courts take both approaches, begin with Skidmore or kind of end with Skidmore. You can use Skidmore without necessarily saying so, and that will certainly continue. That agency expertise will be valued. And then just kind of last point, what's Skidmore about? I think in part kind of respect for what's been and not wanting to upset stuff too much. And disruption usually is a negative. And I think the court will continue to be mindful of that, whether it says it's thinking about Skidmore or not. It's going to weigh. The justices will think about how disruptive a particular ruling will be, and in that sense, respect, deference, whatever, will continue to.
Great. Second issue raised by the court. So the court said that in particular cases, the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. And the court gives some examples, including one that exempts from provisions of the Fair Labor Standards Act individuals who provide companion services to individuals who are unable to care for themselves, as such terms are defined and delimited by regulations of the Secretary, meaning the Secretary of Labor. How likely is this principle likely to be? How broad is this principle likely to be? So Gene had the opportunity to exercise his discretion at the time he served as Secretary of Labor, so I'll ask him to address this question first.
I wouldn't say that this principle will be broad, but Ricky, I would say it's very common. In other words, as Abbe and I touched on earlier, there are a whole lot of statutes that confer authority, and sometimes pretty broad authority and discretion to agencies, and that includes to interpret and even define statutory language. You don't have to look any further than the Supreme Court's Consumers Research decision this term, just a few weeks ago, a statute conferring pretty broad authority to the Federal Communications Commission. 3 justices thought it was unconstitutional. So it's a pretty common feature. In fact, Ricky, the specific language that you're using there, the Secretary of Labor's authority to, quote, define and delimit certain statutory terms also appears in the Fair Labor Standards Act with respect to the so-called white-collar overtime exemption. The Secretary can, quote, define and delimit who is an executive, for example, within that overtime exemption. The Fifth Circuit just decided a case on this topic, I think late last year, and upheld unanimously the Labor Department's determination of what the sort of salary threshold should be. If you're going to be an executive and exempt from overtime under the FLSA, how much should you make? The Labor Department came up with a number. It comes up with a number every few years. And the argument by the challenger was, no, that's not an authority that you have. You can't make salary part of your test. And so what does the Fifth Circuit do? It says, first, our job is to determine whether there's agency authority in this area. It finds there is. We have to find the bounds. It determines that they're there. And, but it also has to assess whether the agency stayed within those boundaries, right? You have to find whether there's delegation. You have to determine the parameters, and then did the agency stay within them? This is where it got a little interesting, because what standard do you apply to determine whether a salary test is part of defining and delimiting a statutory term? The Labor Department's authority to define and delimit is not boundless. So what's the boundary? The court spoke in terms of what was reasonable, what was rational, what was consistent with. They used kind of Chevron-type language to determine whether the agency was within that delegation. I guess one other observation I want to make in this area is that, and I said at the outset, one of my predictions, I'm standing by it, that Loper Bright will affect how agencies behave. Historically, I'm heading an agency or I'm an advocate for the head of an agency. One line of attack to achieve something I want with the regulation is to find an ambiguity in the statute, take that to the agency head and say, look, you got an ambiguous statute. I'm offering you a reasonable interpretation. Please make the rule I'd like you to make. That now is kind of a perilous game. And for me, as an advocate now before agencies, I'd rather not tempt agencies into defining statutory language. I would rather persuade them to rely on fact-finding, or in some cases even policy judgments within their remit, because Then, when they're in court, they're playing on their turf. It's arbitrary and capricious review versus tempting them into an aggressive statutory interpretation that once they're in court, all bets are off. So I think that's another way in which Loper Bright will, to some extent, constrain agency behavior, even within delegations that might seem in some ways broad.
Yeah, I think you're already seeing when agencies are writing rules, and this happened before Loper Bright, agencies are striving to write these rules in the language of, this is the single best interpretation, and it's very consistent with the way we've interpreted it over time. The language of the rules looks different than it looked 15, 20 years ago for exactly the reasons that Gene just stated.
Thanks. So as you can see, there's considerable complexity here that are raised by these two issues. I want to turn to something slightly different, which is how Loper Bright potentially affects two other decisions that have recently gotten significant Supreme Court attention. The major questions doctrine and the non-delegation doctrine. So let's start with the major questions doctrine. The court held in 2022 in West Virginia versus EPA that this doctrine applies to interpretations that are unheralded, transformative, and economically and politically significant. The West Virginia opinion says that in certain extraordinary cases, both separation of powers principles and a practical understanding of legislative intent make us reluctant to read into ambiguous statutory text the delegation claimed to be lurking there. To convince us otherwise, something more than a merely plausible textual basis for the agency action is necessary. But with the overruling of Chevron, merely plausible agency interpretations will not be upheld because Loper Bright requires agencies to use the best interpretations. So how, if at all, is Loper Bright likely to affect the scope of the major questions doctrine? Abbe will start.
So I think this is actually very much related to the question Gene just answered, because it's all wrapped up in delegation. So I don't think that the major questions doctrine changes at all after Loper Bright. And the reason it is that before Loper Bright was decided, the court had already decided that major questions was baked into plain meaning. It didn't require a finding of ambiguity. So regardless of whether you were trying to determine, is this delegation ambiguous under Chevron, or is this delegation the single best reading of the statute, like you're required to do under Loper Bright, either way, the court has said that inherent in that ordinary meaning interpretation, you have to presume that Congress does not intend to delegate in a big, novel way, unless it says so explicitly. So the court in the post-COVID cases had really doubled down on that and baked it into ordinary meaning. So it's not going to change. It's just going to be very effective in this context. Now, I want to make two more points about that. The second point comes from the FCC versus Consumers Research case that Gene mentioned. That's a Justice Kagan opinion where she upholds this universal service contribution scheme, saying it meets the intelligible principle test. Gene just said 3 justices dissented and disagreed with her application. Justice Kavanaugh concurred. And because he's been writing a lot of the Loper Bright opinions or concurring in them, it's worth just pausing on what he said because it's also very interesting. He said, I'm not so worried about delegation anymore because we have 2 great things now. We have Loper Bright and we have major questions. He says very explicitly, Loper Bright means that we, the courts, substitute our own independent judgment for that of the agency and combine that with the enduring strength of the major questions doctrine. Agencies are not going to be able to go rogue. So he sort of steps back and signifies that there might be 6 justices who are not going to be so worried about non-delegation anymore. There's been sort of this non-delegation peak, that it began with Justice Gorsuch and arguably peaked with Loper Bright. And Justice Kavanaugh seems to be signifying that he's okay. In that concurrence, he doubles down again and says, let's remember, we presume as a matter of ordinary meaning that Congress doesn't delegate to agencies in a big way. But then third, he says something really interesting. He then says, he doesn't say this, he says, I'm going to make a totally unnecessary and extraneous point. He doesn't say that, but that's what the point is, okay? Totally unnecessary and extraneous. And what he says is this: as long as we're talking about the major questions rule, I want to tell you that it's not going to apply to national security and foreign affairs. So he goes out of his way, after he's just doubled down on major questions and says how great it is for his concerns, and he says, you know why? Because when it comes to national security and foreign affairs, the interpretive presumption is reversed. We assume, we presume that Congress intends to give the secretary, the line to use is like discretion unfettered from statutory constraint. So Justice Kavanaugh is doing two really interesting things. He's signaling that he's not applying the major questions doctrine to the president, right? And he's signaling that when we get a case involving the president's foreign affairs or national security power, not just a regular agency, this is going to look very different. And he's telling us, just like I sort of alluded to in the Skidmore discussion, that and as Gene predicted in one of his predictions, I'm going to give him some money later for getting it right, is that, these doctrines might turn out to look different depending on the subject matter we're dealing with, right? BIA, NLRB, Skidmore, national security, foreign affairs, major questions. That's not the way we normally do statutory interpretation in the Supreme Court. We tend to have transsubstantive doctrines. It's very, very fascinating. I want to say one more quick thing about this before this point goes. There is one more form of deference that seems to have remained that might be of interest to the judges and lawyers in the room. There's a deference known as our deference, which is deference to the agency's own interpretations of its own ambiguous regulations. For many years, people, including Justice Scalia, questioned whether this our deference is actually a good idea. Why are we giving agencies the ability to sort of bootstrap onto their own ambiguity? Whatever, okay? Put that aside, the merits of it, yes or no. The Chief Justice said explicitly, by the way, this Chevron stuff is not implicating our stance. After Loper Bright, a lot of people are curious, is the Chief Justice's prediction correct? Yes, okay? 7 circuits have been citing our left and right, many, including the Ninth Circuit, in the context of deferring to the Sentencing Commission's commentary on the sentencing guidelines. That's the most common continuing our cite. And in the 6 district circuits that haven't cited our yet, all of the district courts have. So that's another area of deference that hasn't gotten a lot of attention, that is clearly sort of still alive after Loper Bright, and something to keep an eye on.
So Gene, non-delegation.
First, a comment on our, which actually was long known as Seminole Rock deference. Then my father, Justice Scalia, wrote this decision, our. It became called our deference, extremely controversial, actually, and now it's been modified by the court in what's called Kaiser deference. But Justice Thomas tells the story that the court were hearing argument a number of years ago in which our was being cited to them as a precedent. And my father, Justice Scalia, leaned back in his chair, and Thomas leaned back next to him. And my father whispered, "One of our worst decisions ever." and Thomas paused, thought about it, and said, "Yes, Nino, and you wrote it." So, non-delegation. To those of us focused on agency power, there have been 4 really interesting issues to track over the last few years. Is Chevron going to be overruled? Will the major question doctrine be kind of formally, explicitly accepted by the court? The removal question, which Paul and Erwin were talking about in the last panel. And then fourth, and in some ways most interesting to me, the non-delegation doctrine. In 2018, you had a case called Gundy, I think, Abbe, you mentioned it, where Justice Gorsuch said the intelligible principle doctrine we've been using to determine when there are unconstitutional delegations is no good. And I've got a new approach. He lays it out. The Chief Justice joined that opinion. Justice Alito wrote a concurring opinion in which he said that I'm not going to reach this now, but I think it makes sense to revisit this issue later. Justice Thomas joined the Gorsuch opinion. And then the next year, when Justice Kavanaugh was now on the court and able to sit and address this issue, he wrote a concurrence suggesting that he also was interested in revisiting the so-called intelligible principle that was a doctrine which was being used to administer the non-delegation doctrine. So in the consumers research case, you had a non-delegation case reaching the Supreme Court, Fifth Circuit finding an excessive delegation, and the Supreme Court, to the surprise of some, just applying the intelligible principle doctrine. The chief goes along with that, doesn't express any prior misgivings. Thomas dissents, Gorsuch dissents, Alito dissents, and Kavanaugh writes a concurrence to say, among other things, that the intelligible principle doctrine, quote, has had staying power, quote, suggesting that, what I said back in 2019 about revisiting non-delegation? Maybe we don't need to. Now, Abbe's already touched on part of the reason he said that. In his opinion, Justice Kavanaugh said, now that we've got Loper Bright to constrain the administrative state, as well as the major question doctrine, maybe there will just be fewer delegations of concern and therefore less reason to revisit this test. I think this story is still to be written. In Loper Bright itself, as I mentioned, there were a couple of points where the Supreme Court said, of course there are going to be delegations, this was the delegation assurance, but they are subject to constitutional limits. I think that the Consumers Research case was not a particularly good vehicle to revisit how to define the non-delegation doctrine. I think you could also say that even as it was applied in that decision, by the way, written by Justice Kagan, it was a pretty robust version of the intelligible principle doctrine. But this remains an issue that's going to be closely watched, still to be litigated. The court, I think, will have to take it on more directly sometime in the next few years. It is another backstop, plainly, on delegations to agencies.
Great. So now let's explore whether Loper Bright should be regarded, as some people regard it, as an anti-regulatory decision. In this regard, it's interesting that the political valence of Chevron shifts markedly throughout the years. Most people forget, or probably never knew, the full name of the Chevron case. It was Chevron versus Natural Resources Defense Council. NRDC, a major national environmental group, argued against deference to EPA in that case because the action undertaken by the Reagan administration was deregulatory. But over the years, the valence switched, and Chevron came to be seen as a friend of regulation. On the other hand, Loper Bright indicates that agency interpretations are more likely to be upheld if they are contemporaneous with the enactment of the statute and are long-standing. So, for example, the current administration is committed to undertake unusually aggressive deregulatory action. Is Loper Bright likely to be its friend or its foe? Gene.
Yeah, it's a great question. I think Paul Clement's observation in the last panel that you've got to consider these kinds of questions across a number of different presidential cycles before reaching judgment about whether it's politically loaded one way or another. That's a reminder that's certainly relevant in this context. To those who thought that what the Supreme Court was up to, last term with Loper Bright was, putting the shackles on the Biden administration and, thought that was a bad thing. Well, those shackles are now being cited, I'm sure, continually in lawsuits challenging actions by the Trump administration. And so Chevron is certainly a case that was useful to presidents and their administrations of both parties. And in that sense, it's neither regulatory nor deregulatory. It's going to make it harder for this administration to do certain rulemakings, just as it made it harder for the Biden administration. I think there are other ways in which it's probably on balance deregulatory. First, it just makes regulation more challenging. I think that pushes you in the direction of a little less regulation. There's no doubt that it takes a little power away from the regulatory state, vesting it instead in the courts. That, in a sense, is deregulatory. It takes regulatory power away a little bit from the agencies. And as I mentioned earlier, if you're an agency head weighing different courses of action, I think in the past, you had Chevron deference. When in doubt, go for it, and see what happens. I just have to find ambiguity and be reasonable. How hard can that be? But that constraint is now in place. The last thing I'll say about this is, back to Skidmore. I don't think Skidmore is going to be a huge factor going forward, but Skidmore itself reflects a sort of respect for what's been done for a long time, for tradition. The government's chances of getting Skidmore respect are highest when it's a long-standing agency interpretation. It's persuasive and actually dates to the inception of that particular statute. That's a conservative concept, actually, in part for reasons I suggested earlier. So I think in that way, too, on balance, Loper Bright is a little bit more kind of deregulatory than pro-regulatory, but it's not as easy as it was suggested a year ago when the case came down.
Can I jump in quickly on this? So I think one thing to keep in mind is that Loper Bright creates arguably a race to the courthouse, right? Remember my example about sex in the Affordable Care Act. Now, the first case that gets to the top to interpret the term sex, that's going to be fixed in the statutory meaning forever. So it's deregulatory in the sense that it doesn't give a later agency the chance to evolve the meaning of a statute or change the meaning of a statute in response to questionable changing evidence or changing interpretation of what capacious terms like the term sex might mean in the context of a non-discrimination act, right? So it's deregulatory in the sense that it's deregulatory, it's anti-regulatory for the next guy, right? Because the person in the seat now has a lot of authority to try to fix the meaning of statutory terms that people really, really care about. The other thing is, a lot of it depends on which way the statutory text cuts, right? If you have a statutory textual definition that's really in your favor that happens to be pro-regulation or anti-regulation, if you take the court at its word, then a textual interpretation as opposed to a politically driven determination, which is what Chevron licensed and allowed and endorsed, is going to carry the day. I also think Gene alluded to the idea that movements away from the status quo have the potential to trigger Skidmore and the major questions doctrine, to the extent courts want to let them be triggered. So if deregulation in this moment is a big move that is different from what's come before, you might not get Skidmore deference. And you might find yourself facing the major questions doctrine. Right? And in that sense, the moment we're in now could provide some resistance to deregulation. But I agree with Gene that it's very difficult to predict.
Just one last, last quick comment on that, sort of the race to the courthouse point. It's actually even more complicated than that, because you sue over that regulation and you win in one circuit. Well, that may get litigated somewhere else in another circuit, and Loper Bright will send more issues to the Supreme Court for ultimate resolution. And the business community was not really that excited to overrule Chevron. Right now, the business community would like to think that in a number of circumstances, if it could go to the current administration and obtain a disposition that was favorable under a regulatory program, that would get deference and have staying power in the courts. Now, like I said, it's a jump ball, and big business, God love them, they like predictability, certainty, the ability to plan. Loper Bright actually makes that a little harder for that reason.
Okay, I'll make a prediction. I think I should have the authority to make a prediction as a moderator. So the current administration thinks that Loper Bright will be its friend and basically cites the overruling of Chevron in various executive orders and agency guidances and policies, and says that it will use that as the way to do aggressive deregulation. My prediction is that it will find that Loper Bright is not as much of its friend as it thinks it is. I will not make any further predictions on the percentage of which it will find its friend, it'll find it friendly, but I think it will be disappointed. So you've both alluded to this briefly, and I want to spend a little more time on it. So the question is, to what extent is Loper Bright likely to have different impacts in different areas of regulation? And I'll ask Gene to address the immigration area and Abbe to address the healthcare area.
Yeah, on immigration, I was here for the earlier panel on judicial independence. I know that's very important, obviously, particularly to this group. And on that subject, I have good news, which is that federal judges are now going to have judicial independence when it comes to interpreting the immigration statutes, and will no longer be bound by the shackles of what the BIA has to say. You can interpret that statute all by yourself. You can, in fact, spend more time now on your immigration docket because different doctrines won't apply. Now, I'm kidding, but actually, one possible change to that is that the Biden administration was arguing that deference was due the Bureau of Immigration Affairs, not under Chevron, but under a provision, 8 U.S.C. 1103A1, which it says expressly gives the Attorney General controlling authority in interpreting the immigration law. So that's actually what that provision says, that the Attorney General's legal determinations are controlling, and the Biden administration was using that. I assume the Trump administration will use it. That would obviously be a deference principle, and a really strong one, obviously, as well. There's a good counter-argument, which is when you actually read the whole provision, it begins by talking about the authority of the Department of Homeland Security. It then talks about the authority of the Secretary of State. And then it says at the bottom, oh, and on questions of law, the opinions of the Attorney General are controlling. So the counter-argument is that's just controlling within the executive branch, not controlling of the courts. So I don't know how that will play out, but assuming that the Justice Department loses that argument, immigration law is one where often there are statutory terms to be interpreted without any express delegation to the government, and immigration lawyers who represent immigrants are arguing that, hey, Loper Bright is great news for us. Courts should not be deferring to the government. There have been a number of cases already addressing this question. There's one from this circuit, Lopez, which used Skidmore to give a lot of weight to an opinion of BIA that had been around for a while. The flip side, there's a really interesting Sixth Circuit decision, I think it's Montezuma-Reyes, where Judge Thapar is looking at the question of what is exceptional and extremely unusual hardship. And he says, I'm a judge. I interpret for a living. I can tell you what that means. Hardship is like bad stuff. And exceptional is really bad. And extremely unusual is like really, really unusual. And so he says, this is a high bar. At the very end, he says, oh, by the way, the BIA has a similar interpretation. Good for them. He says, by the way, I don't have to use Skidmore. It's optional. He's taken to task by Judge Stranch, who says a couple of interesting things. She says, wait a minute, we've got precedent interpreting what is exceptional, extremely unusual hardship. Now, it's Chevron precedent, but look at what the Supreme Court said about Chevron precedents. They're still good. And she says, why did you not use Skidmore? You should have started there. So these are, we're seeing some of the debates that I'd alluded to earlier in that one decision. But I think by and large, immigration law is now going to demand more statutory interpretation without deference.
Healthcare. I'm going to be brief to give you time to talk about the environment. I'm going to question the questioner if you want to talk about the EPA. But in the healthcare context, a lot of the pre-Loper Bright cases were actually healthcare cases. And so I would argue that in the healthcare field, the field kind of pre-adjusted to what they saw the end coming. And a lot of, in the healthcare realm, a lot of the cases leading up to Loper Bright were already using a lot of these best interpretation method, including the cases that were in the Supreme Court leading up to Loper Bright, which is one of the reasons why the court hasn't cited Chevron in something like 5 years before Loper Bright was actually argued. In the healthcare context, you're seeing sort of three phenomena. One is in sort of run-of-the-mill cases, people are trying to open up the case saying, well, this was argued under Chevron, let's reopen it. The courts say, we would have reached the same answer anyway. The Chevron answer was the single best answer. Let's keep things steady. This sort of goes along with what Gene is saying about courts being reluctant to sort of upset things too much. In the FDA context, we are seeing a lot more willingness to challenge FDA decision-making. So whereas the FDA always had this broad presumption of scientific deference, what we're seeing, and I think this, in my view, is the huge loss of Loper Bright, is we're seeing a lot of less deference to scientific expertise when you're seeing agencies, expert agencies like the FDA. We're just seeing a bigger willingness to challenge the FDA, with Loper Bright being cited left and right when they're challenging FDA decision-making on various scientific matters. In the big political controversial cases, which is where Chevron really did a lot of work, remember those swinging cases that I was talking about, like the Affordable Care Act non-discrimination case, that is where you're seeing it. Within 3 days of Loper Bright, there were 4 injunctions across the circuits saying President Biden's interpretation of sex in that Affordable Care Act non-discrimination provision, citing Loper Bright, saying, hold on, right? You don't get Chevron for this. We've got to turn this ship around. And you're seeing something like that in the Title X federal funding for abortion services cases that are going on now, the same phenomenon. So I would say that run-of-the-mill cases, not a huge amount of disruption, more willingness to question scientific authority, which I would say is the biggest loss here. And third, really going after, because of that race to the clock that I mentioned, the big ticket political decisions that have been made in the healthcare realm, using Loper Bright as your primary weapon. Do you want to talk
on the
about
environmental area? Yeah, this is a hard one, actually, because on the one hand, several of the recent Supreme Court decisions that have widely been regarded to have anti-regulatory consequences, including West Virginia versus EPA, the major questions doctrine case, have been in the environmental area. So that might be signaling something. On the other hand, as I suggested in one of my questions, aggressive deregulatory measures inconsistent with regulatory antecedents extending back decades are unlikely to do well under the Loper Bright framework. So as opposed to say, I'm calling this one too early to tell. We'll see. We have some good questions, but not a lot of time for answers. So I'll merge two of them and I'll ask for very quick responses. So first one, to what extent is Loper Bright a consequence of a broader societal rejection of the value of expertise and the concept of objective scientific truth? And a related question, if deference is based on agency expertise, what happens when and if executive appointments are folks with no expertise, but are there based on political aligned philosophies? So if you could each briefly say something about these two questions.
Yeah, sure. I don't want to be overeager, but I'm happy to take that one. Loper Bright is a really powerful manifestation of a court that is bought in on textualism and originalism. And I think that 20 years ago, you would not have seen a decision like this, which says, look, there's a single best fixed meaning. Go find it. And the court didn't talk that way 20 years ago. So I think that's what it reflects. In terms of expertise, what I would say is au contraire. I think one of the main reasons the court got tired of Chevron is, although originally maybe people thought that agency determinations were going to be expertise-driven, what the court watched for 40 years was the Republicans do this, the Democrats do that. Republicans are back, they do this again, Democrats do that. The net neutrality Sixth Circuit decision I mentioned a moment ago, this ping pong ball has been going back and forth for at least 3 administrations. And I think what the court saw is this isn't expertise. This is just politics masquerading as law, by the way, often by independent agencies that we're a little skeptical of to begin with. So I think that's what's going on there, and it's not wrong, but in fact, it's probably constitutionally correct. But there is more political control today of the administrative state, and therefore it became clear the decisions were less expert-driven often.
Well, let me say something related but slightly different. I work in the healthcare realm. I think we are facing a crisis of lost reliance on expertise. Richard Posner and I did a survey about 8 years ago. We talked to a lot of judges about Chevron, and while there was a lot of debate among judges of all political stripes about the value of Chevron, 2 things really emerged. One, many judges thought that Chevron should have been sort of divided between technical questions and non-technical questions, right? The Ninth Circuit can decide the meaning of the word "the" just as easily as the agency can, but maybe not the word "pets" in my first example, right? When a statute is regulating pets. So there was a lot of sort of, even from very liberal judges, this idea that maybe Chevron had gone too far and there was sort of a rational way, and I always thought that's what was going to happen. I thought we were moving in a direction, because Kaiser versus Wilkie, also the Hour 2 case, kind of alludes to this idea that when an agency is speaking from its expertise, it has particular authority. I think we sort of lost that. I think we have, it is very difficult for judges to figure out how they're going to answer these questions in this time. And in that case, I would say also that the DC Circuit, which obviously gets a huge amount of administrative opinions, no matter what the political stripe of the judge, and these questions were totally confidential, of course, judges were saying that we really need this Chevron thing because, number one, we don't know how to do it, and number two, we don't want to be the ones making these decisions. So whether or not judges want to be making these decisions, you're put in the seat right now, and the question is sort of what is the role? And the last thing I will say is, COVID did, as we all know, erode a lot of confidence in scientific expertise, and that's something that as a country we have to figure out how to recover from.
Okay, I will leave you with a humorous question. There will not be time for the panelists to answer it, but you can think about this. So, question from the audience. One of you went to college in Chicago, one of you teaches in New Haven, and one in New York. If an agency is empowered by statute to regulate pizza, does it reach what is called pizza in Chicago but not New York? Call this a variation of the what is a sandwich debate between Justice Scalia and Judge Posner. Okay, you can all think about this in the break, share ideas, and I will turn time back to Jonathan.
Thank you all. Please give our panel a round of applause. It was an excellent presentation.